Luigi Mangione, the man accused of killing UnitedHealthcare CEO Brian Thompson, will use a psychiatric defense in his state murder trial. In a pretrial hearing today, the judge said Mangione's lawyers will attempt to show that he was suffering from, quote, extreme emotional disturbance. The 28-year-old is accused of fatally shooting Thompson on a New York City sidewalk back in December 2024. Mangione was arrested, as you may remember, just days later at a McDonald's in Pennsylvania. He has pleaded not guilty to state and federal charges. Joining us now is NBC News legal analyst Misty Marris. Misty, just start by explaining what this new wrinkle means, what this new defense could mean for Mangione.
So this is a specific defense under New York law called extreme emotional disturbance. And it means that the defense will argue that Mangione committed the act. He killed Brian Thompson, but that it does not amount to a second-degree murder, which he is charged with. It could result in a conviction on a lesser charge of manslaughter if it's successful. Now, it's important to note, he's still pleading not guilty because those charges against him are the murder charges. So this is a way to mitigate a potential the charges and ultimately the sentence.
Yeah, and you were telling me he still pleads not guilty,
correct,
technically, to that murder charge, but perhaps gets a better result.
It gets a better result, and he's saying, I did it.
Right.
But
what is the difference between this and what people think of when they think of an insanity defense?
So part of it's the legal standard and also the impact of it. So in insanity defense, you have to show that you were so detached from reality, you didn't know the difference between right and wrong. And if it's successful, it's an acquittal. It's not guilty by reason of insanity. And what would happen is somebody would go to a facility to be rehabilitated, but not to prison. This is different. This would just reduce the charge from the higher level murder charge to manslaughter and would still result in prison time to the tune of 5 to 25 years.
So what would his defense need to prove in trial to get there?
This is why it's so interesting, because it makes the whole case so much different. So usually the defense doesn't have to say a thing, right? The prosecutors have the burden. But when the defense raises this, it's an affirmative defense, meaning they have to show that he acted with extreme emotional disturbance that caused him to lose control, and that's the reason, and he has to set a reason for why that happened. So they are going to have to show what that extreme emotional disturbance was, and that's likely going to be through experts and medical testimony and information regarding whatever led up to that incident.
And just quickly, there was 2 weeks ago a private hearing having to do with a psychiatric defense, and that was sealed, right? So we won't see that?
So we're likely to see some of what was talked about during that hearing now that the judge has determined the defense can move forward with extreme emotional disturbance. But before it was sealed, because it's highly confidential medical information, and at the time, didn't know whether or not the defense was able to argue it, and it's to prevent prejudice in both the federal and the state trial, which is upcoming.
All right, Misty Marris, always great to have you. Thank you.